Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because they agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as Your Law Intellect. Happy Sunday to each and every one of you. Thank you for all the members that are lit up in green. Thank you so much for Brandon Burks, who became a member before we even started. I so appreciate you. I hope you enjoy the content that we have in the membership only section. We will be going live again this week. So if you have not joined the membership, think about joining the membership section. I also drop a lot of documents and all of that good stuff over there. And pretty cool community, a little bit more laid back than out here on the bigger platform. Thank you guys who have already hit that like button. I see you. I see you. See, usually I'm complaining about the likes, but I see that before I even started, it was about 70 likes. So I appreciate that. And I want you guys to continue that. Welcome to all the new subscribers. We appreciate you as well. For those of you that have left kind words, even those that have not left much, very kind words, we thank you as well for those likes. But anyways, I hope you guys are enjoying your Sunday. We are back on the Keke Palmer case. For those of you that don't know, we are the intellects and we are the social media jurors. And what we do is we gather all the information that we can get. Mainly, we try to use documents. Those are those that are filed with the court, and see what individuals say about certain situations. We discuss cases from the neighborhood to Hollywood. And any cases people email me about they want to talk about, oftentimes I'll discuss if I have time to do so. Thank you, Gwen, for becoming a member. I appreciate you. Crystal, welcome to the Intellects. I thank you so very much. And I also thank each and every one of you guys for spending your Sunday with me, because I know you didn't have to do it. Thank you, CCB. I appreciate that. I need that. Maybe it's getting off the treadmill. I was like, I'm gonna be all sweaty and stuff. But yeah, I you know, it's like 48 degrees here. And I'm a comfort eater, and them cupcakes and them ding dongs at night. So I said, no, I need to go do something about this before it get out of hand. So thank you so much for the compliment and the kind words. I so appreciate it. But let's get to the issue at hand, because somebody's going to be in the comments talking about, why was you talking so much? I didn't come here to hear about your weight and you getting on a treadmill. You know how some people are. Then I got to delete you. Then I got to block you. Then you got to go like, Pam don't care about people's opinions, and all of that. So let me just get to what we're here for. So Keke Palmer, the last two videos we have discussed that we found out that according to her, because this is all an allegation, she has been abused by her ex-boyfriend, who is also her baby daddy, Darius Jackson. Now, I had no clue who Darius Jackson was. I didn't know where he came from. And then you, the intellects who are the investigators, because we got PIs, paralegals, secretaries, we're just social media based, came and you advised that he is the brother of Sarunas Jackson from Insecure. So apparently he has been putting hands on Keke since probably towards the beginning of their relationship, 2.5 years. And on November 5th, it was the straw that broke the camel's back because she decided to file a restraining order, but she also wanted to get on paper custody and full legal and physical custody of her child. Because it was an emergency basis, the judge did grant an ex parte restraining order, a temporary restraining order, and also gave her full custody, full physical and legal custody. And Darius cannot come see this baby until they go to court, and they have court in December. So when this happened, the insecure brother from Sarunas, I said the insecure brother, Lord, the brother from the show Insecure, Sarunas, he decided he wanted to do a post and delete. Well, you know, folks do these posts and deletes, and it means absolutely nothing because it's always somebody there that is going to screen grab your post and delete. So you might as well just go ahead and leave it up because it's still going to go viral. We still going to see it because there are some people just waiting on you to say something crazy. So Sarunas did a post and delete after the word got out that Kiki filed this restraining order and requested custody. Thank you so much for the $5. You said, thanks for your research and commentary. Here's my 2 cents. Thank you. I appreciate you. Bahati Kumba. Thank you so much. So what Sarunas said was the most, after all of this, these headlines came out, the most disgusting, vile, abusive, manipulative person I have ever, and he had ever in all caps, encountered in my entire life. Abuses almost everyone. Y'all will see. ... Just send positive energy to the babies. First, he had an S, so I was like, what? ... Any child in the middle of something like this does not deserve it at all. And he has that in caps. Wow, so damn sad. But he must have got lit up in that chat because he immediately deleted it. But it wasn't until Kiki's mom saw it and she did a video, which we talked about in the very first video we discussed about Kiki. And the mom made an allegation of, I told you that my daughter was getting knocked upside her head by your brother, and you said, "Oh, that's okay. I used to be that way." And then, of course, Sarunas, whatever his name is, he came back and he said, "That is not true. I never said that." I'm paraphrasing, of course. He said, "And I have some recordings of you threatening my family and blah, blah, and everybody, the whole world is going to see." That basically, I guess he was saying his brother wasn't a problem. So apparently Sarunas was in some type of situation where he had a girlfriend and he ended up getting someone named Dominique pregnant on Insecure, one of his castmates. So it was drama back in the day, I guess, about that. I wasn't privy to that. But I'm learning that now that there was drama. So Sarunas has a baby mama named Dominique, who is also an actress. Well, Dominique apparently did a meme of Michael Jackson eating popcorn. And somehow people took that as if she was making fun of abuse. I don't know how they took it that way, but I guess, interpretation is interpretation. So she being Dominique, felt like she needed to clarify and say she did a post as well, and it's still up on her Instagram, where she said there was a repost of a post I made on yesterday. There's situations where you laugh to keep from crying. Let me give clarity. I would never laugh at anyone that is subject to domestic abuse, female or male. As it's known, abuse comes in different definitions, silent and physical. Only the people enduring such behavior truly understand the effect. Women have been manipulated, abused, lied on for centuries, and put their head down for the fear of not being believed. We need to stop being afraid. I may not be at the highest platform in my career just yet, to be heard and or supported by the public. But whenever that time comes, everyone will listen. God is in control of my steps and I'll respond accordingly. I will be vindicated in his timing. Pray for the abusers. The protected babies will always be fine. So everyone was in her chat like, her? Like, ma'am, can you please clarify what you're talking about? Because people made assumptions that what she was insinuating is that perhaps she may have been subjected to that. You know, it was in her comments. You can go over there. So with me, I just decided to do a little bit of researching to see, hey, is there any cases that she's involved with since Sarunas and her want to talk and get into Kiki's business? And what I learned was that Dominique and Sarunas are in a currently fresh custody battle right now. In fact, it is so fresh, guys. They have a case, they have a hearing on the exact same day that Kiki has her hearing with Darius about the whole restraining order and all of that. Because, like I explained before, it's ex parte, so it's one-sided. For due process purposes, he is entitled to a hearing within a reasonable amount of time, so that the judge can decide whether they're going to keep it on there, lower restrictions, or whatever. This was an emergency situation. So when I actually was looking at the document, Sarunas is the one that filed. And this may have affected why Kiki said, let me go ahead, because apparently he's been abusive according to her for a couple of years. So I would surmise, and again, this is just my opinion, that perhaps when she saw how Sarunas was moving, she said, maybe I need to get something in place. Because at first glance, when I looked at the document that was filed, it was just a form filing asking for, he wasn't asking for full custody or anything like that. What he was asking for was, let me see if this document, this is it. Wait a minute. No, that's not the one I want. What he was actually asking for was just joint legal and physical custody. So it wasn't it wasn't a whole lot, right? So when I saw it, I'm like, well, that's not real uncommon for someone to say, okay, I want joint legal and physical custody. In fact, I think at this point, it's not old school anymore, where a lot of times it was almost assumed the mother will get the majority of physical custody. Legal, they usually don't have a problem with. Usually that'll be joint, even if one person has primary and the other one doesn't. When it comes to legal, because that's your well-being, that's your education, that's your health, etc. So they do want you to confer on that, as long as you don't have no baby daddy or ex-husband or whatever that you just can't talk to, or it's an abuse situation where it's unsafe. Typically the courts do want you to have joint. As years have progressed, they do like joint physical custody as well. I've seen it lean towards that, at least in my state, where it kind of starts out where they like joint on both sides, especially if both parents have been in the life since the beginning. So when I saw this, I said, oh, okay. So what he was saying in this document is a petition to determine parental relationship. So what Sarunas did was he said he wants to be determined as a parent of the children in item 2, because he's the biological father. Then they have the child. So he says the court has jurisdiction over the respondent and the respondent is Dominique. He is alleging that Dominique lives in this state, which would be California. And we're going to get into that in a minute because that's important. He also said the action is brought in his county because the children live in the area found in the county. Petitioner claims respondent is the parent of the children listed in item 2 above. So then he goes on and said child custody and visitation and parenting. So what he is asking for, as you guys see, he wants joint legal custody and joint physical custody. So again, at first glance, it was like, yeah, okay, that's not too uncommon. But then I read further in the docket, and I'm gonna pull up what Dominique responded. According to Dominique, she was blindsided by this filing because she alleges, and we're going to go line by line of what she alleges, but she alleges that she only goes to California. She'll get like a month-to-month rental for work because she's an actress. Her primary residence is in Texas, and she gives a lot of evidence that her primary residence is in Texas. Her daughter is primarily with her. So in September, she's alleging Sarunas knew she was on her way back to Texas because she said she wasn't going to stay in California. The strike that made a lot of actors and actors broke. She can't afford to pay for a month-to-month in California and have her residence in Texas. Most of her family, it appears, is in Texas, who also assists her with raising this child or helping with this child. When he found out she was going to move, according to her, Dominique, she's alleging, and you guys are going to see it in this document, that when he found out, what he did was file this petition, because what the summons does is, when this is filed, it restrains you from being able to leave the state. So what she is saying is that he filed this document to keep her from going back to Texas, which is what she does all the time when she's not working in California. She's a working actress. She goes from place to place. She may stay there for a month. She may stay there for 2 months. So that's what she is alleging, that basically she is not from no California. He did this because the way their summons, which is your notice that you are ordered to respond to whatever it is, the complaint petition, and that you're supposed to go to court. It gives you all the instructions on the summons for those that don't know. In that summons, apparently it says, because it's filed, you cannot leave the state of California. So what she was alleging is he's trying to basically keep her and this baby in California based on filing this, so she can't go to Texas with their child. Thank you, Michelle. Thank you so much, Michelle Led, for the $10. She says, thank you for your intellectual view. Thank you so much for your generous donation. Well, apparently, so why did she tell him before she was back in Texas if he barely sees the child? Then he is on a need to know. Well, let's get into the document so you can have a better. I just wanted to generally let you guys see. There's way more to it, but I want you guys to generally see how this thing went down. So let's see. So what she filed in response, she being Dominique, is a motion to quash service of summons and to stay or dismiss this action per CCP section 418.10 sub A sub 1 sub 2 and the family code. And she's asking for costs and attorney fees for having to respond to this. So let's get down to what she is alleging. And this is going to make you guys understand more thoroughly what I was just summarizing. Some of the stuff, she gives more information about their child. I don't know how much she talks about her child on her Instagram, because I don't follow her. So a lot of things that seem way too personal, I did try to block out. So you'll see some redactions when it comes to the child. She also had pictures and stuff because she was trying to prove where the child is most of the time. I didn't put those as well. I'm not going to show the pictures of the child. But anyway, so this is the declaration of Dominique Perry. She says, I'm the respondent in the above reference matter. And she basically says that if she's requested to testify, she will testify to this. So let's do introduction and background and facts Petitioner Sarunas Jackson and I were never married. However, we are the parents of a beautiful and amazing, precious daughter, Zen. Since Zen's birth, despite the emotional volatility and intimidation that petitioner has directed towards me, I have been committed to fostering a positive co parenting relationship with petitioner because I know that it's in Zen's best interest. To that end, petitioner has never been denied the opportunity to be involved in our daughter's life in any capacity he desired. So, as you guys see in the beginning, she said a little bit in there about her experience, according to her, with dealing with Sarunas in this co-parenting relationship. She says it's been emotional volatility and intimidation that he has directed towards her. So she goes on to say, petitioner and I are employed as actors. When working, our employment often requires us to travel to various locations throughout the country and at times abroad to film. However, I have always maintained my permanent resident or domicile in the state of Texas and have historically only maintained a month to month apartment in California, especially for work obligations, as Hollywood is the entertainment capital of the world. Even as a working actress, it has always been my intention to maintain permanent residence in the state of Texas. While pregnant, I returned to Texas to deliver Zen. Zen was born in Houston, Texas. I maintain a home in the state of Texas. That is where I spend the great majority of my time. And because I have always been Zen's primary caregiver, Zen travels with me and has exclusively lived with me, making her permanent home in Texas as well. All of Zen's milestones and significant life events have occurred in Texas. In fact, before the filing of this parentage action, Zen had not been in California for 6 continuous months. So that must be a criteria because that's how it is in Michigan. You have to be a resident in the state of Michigan for at least 6 months before filing. So she's alleging that her child has never had 6 months continuously in the state of California. Instead, as is customary, she was with me in Texas before we briefly traveled to the state of New Jersey for filming, after which we came to California. However, now that Zen is school age, the transitory lifestyle Zen had previously experienced with the assistance of my mother, whom I have been blessed enough to employ as Zen's caregiver when I am filming, is no longer feasible. Realizing the importance of stability for Zen, now that she is set to start school, I began researching schools in Texas and selected one based on its resources and commitment to providing quality educational experience for children. Another equally important reason for returning to Texas is that I can no longer afford to maintain my California residence and my home in Texas, especially in light of the labor strike that completely shut down production in the entertainment industry. I advised petitioner, which is Sarunas, of my intentions, and he even agreed to accompany Zen and I to Texas so that he could tour the school I had chosen for Zen. So allegedly, he even went to Texas to even tour the school to see if it was a fit for that child. At the time, I was scheduled to leave California with Zen and return to Texas in mid-September so that she could start school and undergo the observation, testing, and assessment periods. At no time did petitioner voice any objection. So hopefully this answers that question that was in the chat. At no time did petitioner voice any objection or opposition to my customary return to Texas or the decision to enroll Zen in school in Texas. And so she attached the school who acknowledged that this child was enrolled in this school that they toured. Rather than petitioner broaching any concerns that he may have had about my intention to return to Texas and enroll Zen in school there, instead, on or about September 15 of 2023, I received notice from petitioner's attorney's office that he intended to make an ex parte request at the courthouse on Monday, September 18, 2023, for an order preventing me from leaving the state of California with our daughter. To take advantage of the court's emergency jurisdiction, petitioner's ruse was that I was intentionally absconding from the jurisdiction to ferret Zen away from him. So, led to get this ex parte and saying it's an emergency, apparently they filed an ex parte, which is a one-sided petition claiming that she was going to take the baby. I don't know what they thought she was going to do. She was going to leave the jurisdiction to hide the baby or something. I don't know what they was trying to allege, but they're saying that, that's what she's alleging here. However, nothing can be further from my truth. And she said that with an exclamation point. My leaving the state of California and returning to the state of Texas has always been a custom and practice that petitioner has recognized and acquiesced in since our daughter was born. In fact, petitioner has frequently traveled to my home in Texas to spend time with our daughter. And despite the status quo of Zen spending most of her time in Texas, it has never prevented or in any way hindered petitioner's ability to spend time with our daughter whenever he desired. Curiously, petitioner's ex parte notice failed to provide a specific department number. Because of that, I had no idea where I should appear or submit my opposition. Additionally, I was giving said notice without even being provided a copy of any underlying parentage action to which the request for ex parte request would attach. So what she's saying is when she was contacted by Sarunas' attorney, he basically gave her notice of this hearing that was going to happen in a couple of days, an ex parte action, but the actual document as to why he believed he was entitled to an ex parte hearing or that a hearing was necessary, period, was not attached. So she had no explanations as to anything that had to do with this any parentage type document. Like, what are you even asking for? That's what she's alleging. So let's go on. Despite my repeated requests, I was never provided conformed copies. So conformed copies are those copies that the court accepts or filings with the court of the operative petition or the ex parte paperwork, and I was never provided with the summons properly issued by the court. Again, a summons is a notice which lets you know you are being summoned. You have 28 days. I'm making up days because it depends on what the action is and what state you're in. You have 28 days to respond to this petition, and it gives your case number, the judge, it gives you all of that, where you can file, how to file, gives you instructions, and all of that. In fact, my repeated requests to be given at a minimum the applicable case number were ignored. So she's alleging she was asking this attorney, can I at least get the case number? And they weren't even providing that. Overwhelmed and confused, I immediately began searching for an attorney. I was given a referral to an attorney in California and immediately began consulting with him with respect to my options. During said consultation, I expressed that my focus was to defeat the ex parte so that I would be allowed to return home because Zen needed to start school and because I frankly could no longer afford to maintain both my home in Texas and pay exorbitant rent in California because California does tax you. My then attorney contacted petitioner's attorney, and apparently a deal was reached wherein the ex parte with its defective notice would be taken off calendar provided I signed a notice and acknowledgement of receipt. So when you sign a notice of acknowledgement and receipt, basically you're saying, I'm accepting service, I'm accepting the jurisdiction, I have these papers. So that's what when you agree to sign it or whatever. So she says, I signed the notice of acknowledgement and receipt, and my attorney at the time was provided a copy of an unfiled petition to establish parental relationship and a summons that had not yet been issued by the court. So she agrees to sign and say, yes, I acknowledge that I received this. But the papers, according to her, that Sarunas' attorney turned over to her wasn't even filed with the court yet. It was not filed, wasn't stamped. That means it probably wasn't a case number or anything on it. And it was also a summons. The court is the one that issues the summons. the summons, now you can, sometimes you have forms, depending on what state, you can fill out the summons primarily yourself, but you have some states that they issue the summons for you in the clerk. She's alleging the summons wasn't even issued by the court. So she signs this acknowledgement, but then in response, they send her a document. So it's almost like you're acknowledging receipt of a document that you haven't really gotten yet because it wasn't even filed with the court, if that makes sense. As I know it can get a little convoluted. So she's saying, I signed the notice and acknowledgement of receipt because I was told it would take care of the petitioner's ex parte request. So she's saying the only reason why she signed the acknowledgement is because her goal was to be able to go back to Texas. So she wanted to make sure that his ex parte motion trying to make her stay and be restrained in California, that would be absolved and that would be negotiated away. Okay, we can deal with the parenting time, we can deal with the custody, we can deal with all of that. But I just want to make sure I can get my tail back to Texas where I can afford it and where my child is in school, where my family is. So that's what it sounds like she relayed to her then lawyer, and that's why she signed it. However, after she signed it, she did her own research and she realized that she was not told that by signing a notice and acknowledgement of a receipt of a duly issued summons and duly filed petition. So she underlines that because she's saying it wasn't duly issued because it was never filed with the court. And she says it wasn't duly filed. She said, I will be restricted from leaving the state of California because there's an automatic restraining order in the summons. So she's saying, had this document really been filed with the court, she hires this lawyer. Let me try to break this down as clear as possible. She hires this lawyer because she doesn't want to be restrained, which is what this ex parte document that he filed, he was trying to do to keep her in the state of California. She agrees to sign this acknowledgement. Okay, I got these papers. I'll acknowledge I got the papers, but I need you to get rid of this ex parte hearing. So they agree, we're going to get rid of the ex parte hearing. You just sign this document. She signs acknowledgement that she receives the documents. The documents ain't even been filed with the court. So it don't even mean anything. The summons hadn't even been filed with the court. So that's why she's underlining duly filed and duly issued. But the catch was within the summons, it must have a provision that says you cannot leave this when you sign acknowledgement. You cannot leave the state of California when you sign this acknowledgement of receipt. You can't leave the state of California. So yes, even though the ex parte motion was, we gonna take that off the docket, it really doesn't matter because he got what he wanted, because you acknowledge receipt in the summons, acknowledging receipt. You know that now you are restrained because you're under the jurisdiction of this court. You're restrained from leaving the state with the child. So basically he got what he wanted without even doing the hearing. So that's what she's saying. So she says, in essence, said attorney made a deal that eliminated the need for the ex parte because he gave petitioner exactly what he wanted without having to work for it. Y'all got it? Y'all hit that like. Your girl's over here working on a Sunday because I want to make sure you guys understand what's happening here and what we're dealing with, allegedly. When I learned of the consequences of signing the notice and acknowledgement of receipt, I discharged said attorney on Monday, September 18th. She said, I got rid of that attorney immediately when I realized you just had me just sign over what I don't want to do. What I hired you for, you just had me hand it to them on the platter. They ain't even got to go to court for it. They don't even have to do none of that. Because I signed this alleged acknowledgement of receipt of these documents, I basically consented. And didn't even know I consented to stay in the state of California. And I'm trying to get up out of here back to Texas. And that was my whole point of hiring you. So she said by the 18th, she did not pass go or collect $200. She got up out of Dodge and she got her a new attorney. So she said, after being advised of my challenge to the notice and acknowledgement and receipt, so now this new attorney is going to challenge it because, first of all, I didn't even know what I was signing. But secondly, it wasn't even filed anyway. What I was acknowledging wasn't even a filed document anyway. So I really didn't acknowledge anything. I acknowledged what you planned on doing in the future. That's not how this works. You're supposed to file it, and then once it's filed and the court acknowledges it, and there's a court case number on it and a judge assigned to it, then I could take notice of acknowledgement that you gave me the papers that you filed. So then, after being advised of my challenge to the notice and acknowledgement and receipt, petitioner's counsel's office renewed their notice of petitioner's intent to obtain an ex parte order preventing me from leaving California with our daughter. So once Sarunas' lawyer found out that she was going to challenge that notice and acknowledgement, then he refiled that same motion that he took off the docket before because he got what he wanted already by her signing that acknowledgement, so that they can go ahead and he can make her stay in the state of California with her daughter. Petitioner's counsel's office continued to ignore my request to be provided with the one specific department of the courthouse where the ex parte request would be heard, 2 conformed copies of the summons and operative petition, and 3 a case number. Although the new ex parte was noticed on or about September 20th, I assume it did not go forward as I have never been provided with any notice of the court's ruling. I am advised and on that basis alleged that on or about September 25th of 2023, my current attorney met and conferred with petitioner's counsel about the status of service and the whereabouts of our daughter. Petitioner's counsel insisted that it would be a violation of the automatic restraining order listed on the summons if I left the state of California with the Zen, in which my attorney countered that the automatic restraining orders were not applicable because, 1, I was not told that by signing them, I would be under the purview of an automatic restraining order set forth on the summons, and 2, more importantly, because I signed a notice and acknowledgement of receipt for a petition that had not yet been filed and a summons that had not yet been issued by the court. It could not have possibly operated to effectuate proper service on me. So she's saying, I never received service because, again, I signed this notice before you had even filed the darn document. But Sarunas' attorney is basically saying this automatic summons is still in effect and you can't leave the state. So their attorney's going back and forth on whether she can leave and whether she can't leave according to the rules and regulations. So hence is what this petition is about. This motion that I'm reading is she's trying to get that whole thing dismissed, and we're going to go forward and see what else she's trying to do. So she says, on September 25th, 2023, at my attorney's request, petitioner's counsel finally provided conformed copies of the summons and petition, which indicate the date the petition was filed and the summons issued by the court was September 21st, 2023. So now it sounds like on September 21st, 2023, this attorney actually did file a summons and petition, and it was actually filed with the court. But again, these are days later than what the original signature for the acknowledgement would have been. This is so, you said if this is true, it sounds shady. It sounds real shady. I'm like, what? Thank you so much, Steph. I appreciate you for the Cash App. So I hope you guys was with me. Because I'm trying to make sure you guys understand. Okay. Let's go on, guys. In the interim, because I believe the state of Texas is Zen's home state for child custody jurisdiction purposes, on September 19, 2023, I initiated a parenting action in the state of Texas. So Dominique said, actually, my petition now was filed before your petition because I filed it in Texas on September 19th of 2023 while you were still trying to get it together over here in California, and yours wasn't dated and issued until September 21st. So really, I'm first now because now I did it in Texas. So you can bring your hind tail over to Texas. But anyways, so then she attached her actual filing that she did with the court on September 19th, which would again make hers appear that it was filed before theirs. Service, so she says, based on the foregoing, pursuant to California Code of Civil Procedures, and they have the sections, I now make this special appearance to bring the instant motion to quash or alternatively a motion to stay or dismiss on the grounds that A, service was improper, therefore the court has no personal jurisdiction over me, and B, the state of California should decline to exercise jurisdiction because it is an inconvenient form under the circumstance of this case, and the state of Texas is a more appropriate forum. So then she goes on to talk about because service has not been properly effectuated, the court's personal jurisdiction over me has not been established. So petitioner has not bothered to attempt to personally serve me despite knowing my address and having ample opportunity to do so. Petitioners claim that service has been effectuated based on my signing of a notice and acknowledgement of receipt of documents that had not yet been filed or issued by the court does not constitute proper service under California law. It is unfathomable to believe that I could have accepted service, a legal process that had not yet been processed by the court. And she has an exclamation point. So, you say that with feeling. I have never authorized my attorney to accept service of process on my behalf, nor to my knowledge has she ever represented that she was authorized to do so. And yes, if your attorney, sometimes attorneys, like I have people that I represent on a regular basis, they will authorize that if they get sued, that I can accept service on their behalf. But you cannot, when people will contact me and say, hey, I know you represented so and such before. Will you accept service on their behalf? I have to get permission from my client. And usually you will get that in writing because you really don't want your client coming back and saying, I never told Pam that she can accept service on my behalf. So yeah, that attorney would have to show that she said she had permission to even accept service on her behalf. Part 3, because California should deemed an inconvenient forum, the case should be dismissed so that custody matters can be adjudicated in the state of Texas. So she says Zen was born in the state of Texas and has spent a great majority of the 5 years since her birth in the state of Texas. Texas is the place where we have always returned despite our many travels due to my employment. I have always maintained a home in Texas. And she has like check stubs she attached. Her voter registration is in Texas. Her SAG after paycheck stub has a Texas address. And because I have always and continue to be Zen's primary caregiver, she has always lived with me in Texas. Zen's primary care physician and her medical records are in Texas. She's enrolled in school in Texas. She has a wide network of family and friends with whom she socializes, enjoys being around when we are home in the state of Texas. Because California is the hub of the entertainment industry, I am intermittently in the state for work purposes. So then she has sub B. Zen has not resided in California for 6 consecutive months before the filing of petitioner's California petition. And so then she lists the date on October 13th through 2022 through December of 2022. They were in Houston, Texas for 2 months. Then December 12th to January 25th, they were in Los Angeles for 1 month. Then February 18th to March, she was in New Jersey for a month. Then March to June for 3 months, she was in Houston. Then I guess in June to the current, she's for 4 months now. She's been in Los Angeles, and she's probably, it sounds like, been in there because she has to, because this petition was signed, because she was planning on leaving in September. Unfortunately, my plans to leave in September, California, have been thwarted by petitioner's counsel's threats that if I do so, I will be in violation of the automatic restraining order set forth in the operative summons. I have been forced to remain in California to both my detriment, financial, and Zen's education and overall well-being. Y'all hit this like button, please, as you come in. Subscribe to the channel if you have not done so already. I'm going to look at your comments for a couple of comments here. You said the petty boys taking the lead for the petty Olympics 2024. That's what Shay said. Shay Luna Midnight. Sharon says, sounds like you're doing a whole bunch of shady stuff. Capricorn moon goddess, that's interesting. She said he should have to pay her California rent for making her stay over this BS. So Dr. Carissa said it's a wrap. She proved jurisdiction. I'm surprised this is an over already. Well, they have court next month. And like I said, for those, because it's 983 of you guys. But in the beginning, I thought it was ironic when I looked at the court dates. They literally have the court date the same day as Kiki going in on that restraining order in custody. Michelle A, thank you so much for the super chat, the $50. Thank you for blessing me like that. She said, this is too much. Thank you for bringing the facts and unbiased truth. That's why I love your channel. Your husband is a real one. Thank you, Michelle A. We appreciate you. Let's see what else. Man. The fact that she's had to take her baby everywhere where there's a living parent is insane. Both of them brothers on some ish. They just want to exert control. That's what Roni Magby had to say. C.A. Williams said her second attorney is much better than the first. And so, yeah. So let's get back. I'll get back to some of your comments. As you guys see, I just start from the bottom because, honey, I can't keep up with everything I'm trying to read. So we're on part C right now. Declining to exercise jurisdiction is in Zen's best interest. Simply put, Texas is Zen's home. Texas is where Zen thrives and is happiest. Texas is where we have established routines and community of family and friends that Zen is both familiar and extremely comfortable with. And it is in the best interest of the child. Judge don't care about the back and forth between your relationships. You can't stand each other, all of that. They don't care. They will look at what's in the best interest of the child. So all of this is very important to a judge. I am looking to return Zen to her comfort zone where she is surrounded by love and support. And then she attached an exhibit D. And there were a bunch of photographs of Zen's life in Texas. So there were photographs for you guys to imagine, because I'm not going to put it up because that don't make sense, because then I'll just be blurring her face out. Because like I said, I don't know how much she put about her child on Instagram. I don't follow her. But it was pictures of like Christmas. It looks like maybe she's with like a grandmother. It was pictures of her like outside of a school, playground friends. She has a lot of colorful pictures of, I guess, her interacting with various people in her community and just her, her tribe in Texas. And she attached a bunch of pictures along with, as I said earlier, she also attached her her personal Dominique, her voters registration. She posted her SAG after checks, got her Texas address. She has, what else did she attach? That might have been it. Maybe it was something else, but she was just basically establishing her jurisdiction and her child. She says, I know established routines, familiarity, and sense of comfort are key components of her overall well-being. I have researched many schools and believe this school that I previously enrolled Zen in is a fantastic fit for her. I know that she will benefit from the program and resources. And she said, sadly, because of this case, I have had to postpone her enrollment. In the interim, however, in an effort to get her acclimated to routines in a classroom setting, I have enrolled her in a homeschooling program through our local Texas school district. So right now, because of all of this, she's saying that she can't enroll her in school. So what she did was enrolled her in a homeschool program through Texas. So she homeschooling the baby until they get all this stuff straight. Thank you, Lily Sweet 098 for the super sticker. I appreciate it so much. So then she attaches that as an exhibit of her homeschooling. She says, however, homeschooling is no substitute for Zen socializing and being around the children her age. Further, because Zen's life has always been centered around Texas, Relevant evidence and witnesses need to resolve the custody issue in this case are in Texas. And she's also saying that in order to help prove her domicile and that Texas is really where she lives at and it's not California, the witnesses that she would call on her behalf live in Texas. She is not going to be able to fly everybody to California in order to testify on her behalf on this custody dispute that Sarunas has now waged. For the entirety of Zen's life, petitioner and I were able to informally agree on visitation. Additionally, I have always informed petitioner about all of the important decisions that need to be made with respect to our daughter. I have also welcomed petitioner's input with respect to any major decisions that must be made for our daughter, even when we, Zen and I, were in Texas. Petitioner's visitation routines are dependent upon when he expresses a desire to see her. I say that again. Petitioner's visitation routines are dependent upon when he expresses a desire to see her. Generally, petitioner's requests to see Zen are sporadic. Because petitioner has attained a certain level of success in his career, he generally works and has to travel even more than I do. I am concerned with whom Zen may be left with in the face of his extended absences. Recently, petitioner expressed a desire to share physical custody on an alternating weekly basis. Although I had extreme reservations about petitioner's proposal, I agreed to give it a test run. Sadly, the experiment was extremely distressing for Zen. Zen had more meltdowns than usual and frequently cried because she wanted to return home. So apparently they've already tried this joint custody thing and it did not work out. And I wonder, does anybody know in the chat? Please tell me any projects that this Sarunas is doing. Like, does he have a movie coming up or something? Is he coming into a nice little chunk of money? Like, what is going on with him in his career? Because Insecure is like canceled, right? Because that's another show I never watched. But I heard it was a good show, and I heard some of the things Amanda Seals has alleged about Sarunas. But what is he doing right now? Like, what is he doing for work? Does anybody know? Anybody? Yeah, they did just get off strike. So that's why you're seeing more people talk about because I have a client that's an actor in California and he's ecstatic they're off strike, but a lot of their movies and all of that, I think they had already filmed them maybe. And a lot of them are like coming up in 2 weeks or whatever. But I'm just wondering what he does. Like, what is he doing now? Oh, so he was on a show on BET when Lauren London. Okay. Okay. All right. Thank you so much for that, Capricorn Moon Goddess. Y'all let me know anything else this guy was on. So, petitioner has always been welcome to visit Zen, not only when he expresses a desire to do so in California, but also in Texas at both my home and my mother's home. Because petitioner has the financial means to travel to visit with our daughter and he travels frequently, so it sounds like he must be doing all right financially. Hopping on a plane to Texas to visit with our daughter is a relatively fast and inexpensive option for him. I am proud to be a working actress, but the industry is tough. The recent labor strike left me in financial despair. I simply can no longer afford California's high cost of living, and I certainly can no longer maintain 2 residences. And now you got to pay for a lawyer too. So that's another added expense. That's probably why she's asking for attorney fees. I have been on the verge of eviction in California, only being able to maintain my apartment because of the generosity and support of my family. While I still act, I have started an LLC so that I may start a business in Texas to supplement my income from acting. And she actually attached her LLC for the business she started in Texas. Although petitioner is considerably more financially established, His financial support is inconsistent and simply not enough to allow me to maintain the quality of life that I have envisioned for Zen. As such, from an economic perspective, it is fiscally irresponsible for me to try to continue to live in California, and Zen's quality of life would be undoubtedly suffer. Let me read that again because I said that totally wrong. It is fiscally irresponsible for me to try to continue to live in California, and Zen's quality of life would undoubtedly suffer. Based on the foregoing, I respectfully request that this honorable court grant my motion in its entirety by determining that California is an inconvenient forum pursuant to the family code and allow the parties to litigate this matter in Texas court. Alternatively, I request that the court either stay this matter so that the respective California and Texas courts can confer to determine jurisdiction, or quash the purported service, which would allow me to finally leave the state of California with the minor child so that she may start school in a more traditional setting. So she's asking for a lot here. So when you do your prayer for relief, is what this is called. You say what you really want, but then if you feel like the judge may not necessarily give you exactly what you want, you give it an alternative. So what she is asking is, Your Honor, can you please just determine that California is inconvenient and that I shouldn't have to be here to litigate this matter? Obviously, we're going to have to deal with custody and all of that, but we need to deal with it in Texas. So if you just say we ain't got jurisdiction, we can be going about our business and do it in Texas because I've already filed something in Texas. So that's what she really wants. But in the alternative, she wants maybe the Texas and the California court can confer, talk to each other and decide amongst themselves, perhaps, to determine, they can determine jurisdiction. Or how about you quash that subpoena? You quash that service that I signed, that acknowledgement that I signed before he even filed this petition, and allow me to leave the state. Because if you quash, which means you just say it isn't there, you dissolve it and say that we're not going to accept that acknowledgement, it's no longer there, it's null and void, then that means that I did not subject myself to what's in that summons, which is saying that I'm going to stay in the state of California and I can get back to Texas and I can save my coins and not be sitting here homeschooling my child, paying in California, even though I'm not necessarily, I don't have a job right now, because she didn't say she was working, like she has something going on in California. I have no need to be here. I'm literally stranded in California until the court says, you know what, we agree with you, Miss Perry. That acknowledgement means nothing because it was signed before they even filed the petition. So you're not subjected to that summons telling you to stay here and you can go. So that's in the alternative. Just go ahead and quash it and say that I can go back to Texas and be on my way. And so that's what she wants in the alternative. So she's giving the court various options for her relief. And so that is what is going on with Sarunas, who was talking about the Kiki matter. And so I was saying in the beginning, because of how Sarunas moved, perhaps, and this is just an opinion, perhaps, not saying that Kiki would have kept on allowing getting allegedly beat up, but that may have prompted her to move faster. That maybe I need to get my stuff in order and make sure things are on paper, because I don't want this cat trying to get no joint custody, full custody, or any of that of our child. And I know, how he is according to her. Because again, this was filed in September. She responded with this motion I just went over in October. And we know that this past week, last Sunday on November 5th, is when the incident occurred with Kiki. On the 9th, that Thursday, Thursday, somewhere in around there, is when Kiki filed the restraining order and all of that, and she moved swiftly. And one of the things she said in the declaration is the reason that she did it was because she was doing it for her child, because of how much she loves her child. Aaliyah TV said I would have been left the state. I don't care. Aaliyah, girl, you keep you some money in the stash to make sure you can get out just in case. But I hear you. I hear you. Wasn't she talking smack about Kiki? Well, no, I am here for the show. From my understanding, unless you're referring to something different, from my understanding, Dominique did a meme of when all this stuff was going on under the video of Kiki's mom or one of those back and forths. What she did was she did that meme. You guys seen it of Michael Jackson eating popcorn like this a movie, or I'm waiting to see what happened. And some people were on her neck because they thought she was making fun of the situation. I didn't necessarily take it that way, but apparently some people did. So she felt the need to clarify herself. And I read the post earlier that she posted, which is still on her Instagram if you go over there. And people were interpreting, because she was talking without talking to them, that perhaps she knows how these Sarunas brothers are. I mean, these Jackson brothers are or something. And she just waiting to see how this thing goes. She didn't mention that she in her own custody battle with Sarunas at the time, which she's in court. So perhaps she didn't. She figured we was all going to figure it out or dig it up because of her statement. But she didn't really say anything about her court case or anything. She didn't tip anybody off that I know of. We all just got nosy and was just looking for it or whatever. I looked at it and knew something had to be going on for her to make the statement that she made. You said, okay, got it. If you got something else, then maybe, but that's what I know. But it may be more to it. C.A. Williams said both Kiki and Dominique are making smart moves now. Yes. Elsie said, Kiki said, I'm gonna get you before you get me. I Am Unique said, two trashy brothers, two nickels rubbed together, they ain't worth a dime. You said forcing her to stay in California, restricting her movements to financially deplete her sounds like financial abuse. And that's from Tweet 5 Girls 101. My four girls said, I believe the child was born in Texas and I will help her. Yeah. So that's that, guys. Yeah, Carla Martin said her lawyer is on point. Look, her lawyer was passionate because I seen them exclamation points. And as you guys tell, I do a lot of writing. So when I literally can hear people talking in my head and everything, how they're saying it. Because there's times I write and I'm just like, can you believe this, judge? You know, you want them to almost hear you saying it while they're reading it. It's like, can you believe this foolishness? And to top it all off, Your Honor, do you know that what he did was blah, blah, blah? You know, you want them to hear you're appalled that this is even happening right now. This is just unfair. This is injustice. I hit a lot of tables, as you probably can tell. Royalty said, I looked him up in IMDb and he doesn't look like he has any projects currently, but last appeared in episode 43 of Bill Bellamy's podcast this year. Well, that ain't enough. It ain't enough. Like what? You said neither one of them got popping careers. That's why I am here for the show, said Andrea Moore said that BET show has been canceled. Oh Lord. So I wonder what is he doing? Like what? Because the way California goes too, let me show you guys something that I noticed as well. In the petition, the way it goes is, let me see. They have at the bottom, notice, if you have a child from this relationship, the court is required to order child support based upon the income of both parents. Support normally continues until the child is 18. So once he filed this, it's going to trigger child support as well. You should supply the court with information about your finances. Otherwise, the child support order will be based upon information supplied by the other parent. Any party required to pay child support must pay interest on overdue amounts at the legal rate, which is currently 10%. And they quote legal. So when you late, you could get a killing off them child support interest. It's like you pay $100 when you missed that first week, you owe $10. So they tax 10% interest as a legal interest when you don't pay your child support. So this is also triggered child support. That's why I was wondering, like, who is working here? This can get real expensive. It's always, I, it's a catch 22, especially since they were never in a relationship, it seems. From my understanding, he had a girlfriend, got this girl pregnant and all of that while he had a girlfriend. And it's a catch 22 because you really don't want to involve the courts if you don't have to, if you can be cordial. But the problem with that is you can have every intent where in the beginning it seems like you're going to be cordial. And then you don't know how the other person is going to be when they get in a relationship. You don't know how they might start tripping. I don't want my kid around this person. You don't know. You just don't know. Like, you just don't know how they are. So from that perspective, it's always better to have something on paper so you don't have to worry about that type of stuff. But again, you trigger child support because they don't care. Child support belongs to the child. You cannot waive child support. And you can't waive it where I'm at. So you're gonna pay child support when you decide to get in the system like that. It's no. Now when you do divorces, oftentimes they'll do it different and say we're gonna do it the same way we always did because we were in the same house. So he's just gonna take care and do his portion when he got them. I'm gonna take care when I do my portion or something. But when you have these babies or whatever and you're not married, it's totally like they care about the child. Child support belongs to the child. That's what the court will tell you. So you cannot negotiate that away. Means you cannot negotiate that away. So you can't say, well, he can give 50, that he been given enough, when he wants to, and he does what he can when he can. No, the court is going to say, how much you make? Let me put you into this child support formula. And then you're going to pay $1,000 or whatever it is every 2 weeks, and you're going to be crying. And then you're going to be doing a post on Instagram talking about these women is raping me out of my money because you done filed this. So you see the notice at the bottom that somebody's going to have to pay some child support, and it's based on both of your incomes. And again, there's a calculation. So what I will say is your overnights are important. So when you have there's software for it in most states, the software here, and you put in the overnight. So if you got 200 overnights and they only have 100 overnights or whatever it is, obviously you have the child more, and that affects your child support. If you have it in half, oftentimes it affects you paying less child support if you have half the time, which is joint. Y'all get what I'm picking up, what I'm putting down? So sometimes when you get joint, it can absolve you from having to pay as much, or if your pay is equal, then it's dang near like you ain't got to pay anyway because both of your income is equal, because they do take into account both parents' income. It's not just one side. Yes, based on custody. When you say sole custody, it's two portions to it. You have sole physical custody, which is where the child is the majority of the time, and sole legal custody. So just saying sole custody does not encompass both aspects. So legal custody is I have to confer with you before I make a medical decision. School, like what she was doing. It sounds like she was doing that anyway. Before she enrolled him in school, you come down here and you got to tour the school, you're able to come to doctor's appointments. She was already including him in everything that had to do with the welfare of the child. That's legal. Believe it or not, there are some situations where the court feels like one parent ain't even capable to help with legal, so we just gonna leave it all on one. But most of the time they do that joint. Physical, obviously, is what it says, where the child is the majority of the time. So oftentimes when you're in separate states, they may make it where if you're in separate states, that every other weekend and a couple of days, or you got 2 weeks in the summer and then you alternate holidays, they have schedules for that. And when one person has sole custody, when you have joint physical custody and you live in separate states, there's a whole different monster, right? Because the child is in school age. You have a lot that you have to consider. And sometimes the judge will make it where you pay for them to get to the other state and they pay to get them back. It's just a lot when it comes to child custody and all of that. That's why I try not to do it at all. Because I always say, people will ask me, Pam, why did you do defense work? These people are horrible, blah, 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 blah. We don't, they committed these crimes. Why would you represent them? First of all, they had a right to representation. If it was you or yours, you would want them to be represented as well, and they're innocent until proven guilty. But aside from that aspect, from a practice standpoint, when you have defense clients, they are usually, if they did it bad, I say they are bad people, but they're on their best behavior. When it comes to that, their freedom is on the line. They're on their best behavior. When you deal with family law, oftentimes they are, quote, good people on their worst behavior. So they fight over everything. She was an hour late. She was supposed to have a baby FaceTime before she went to bed and she skipped it. She was 2 minutes late. Oh, she kept a fork and the judgment said that I get my grandma's forks. Oh, she wasn't supposed to have an overnight, and and her son told me that a girlfriend spent the night before. I seen pictures on Instagram at his parenting time, and he didn't have a baby, and he was out there at the Usher concert. That's the type of stuff you deal with, and I just don't have that. You know what I'm saying? I'm like, y'all, come on. So there are some people that specialize in doing family law. It just ain't really my thing. I've done it and I do it, and I've been to trial on family law cases, so I'm well versed in it for my state, but I try not to make that primary because some of these people argue over everything, and I'm just like, y'all so petty. Stop. So Lisa said he is also in the series Good Trouble, and that has been renewed. Well, okay. I'm gonna have to check. Is Good Trouble about John Lewis, perhaps? That's what he always talked about. John Lewis. I got my stamps. I got my RGB stamps. I know people hate getting my mail. They like, she always making us know Black history and women's history every time we get a letter from her office. It's taxing, and I hate evals for family, y'all. Yes, and most of them, they do send you to like, they do try to. A lot of them settle. I just have been one of the unfortunate ones that went to trial, but for the most part, they usually do settle and come to some consensus. You go to some type of mediation in order to resolve your issues, but it can get really, really nasty. Get really, really nasty. Leo said, "Oh yeah, I went through it myself, and you definitely become petty. Both parties and argue over everything every minute. They're late, but we matured and no longer go by the order." Yes, that's how it starts in the beginning because you're still in your emotions, and it's understandable, You're in your feelings, But I used to tell my clients, I'm like, if you can't stand them, I'm like, from a logical standpoint, if you can't stand them, why are you fighting over every little thing? Now I gotta file motions, and you gotta see their face every week. Like, I wouldn't want to see anybody's face every week if I don't like them anymore. But whenever you want to argue over stuff and complain and let the judge know that they did that and they did this and they did that, I'm like, can you let some of this stuff go? Just a few of these things. Can you just let a couple of these things go? Because you're basically forcing yourself to see the person that you feel like caused distress or emotional issues with your life. Like, why do you want to see them all the time? But it is what it is. Anyway, I hope you guys enjoyed the live. Thank you so much again for all of the super chats and the cash apps that I have received. I think I thanked everybody for the cash apps. Let me see. Steph and Linda, thank you so much for the cash apps. I appreciate it. I hope you guys enjoyed the live. Make sure you put, what we gonna put at? You said Good Trouble is about two sisters who are starting new lives in LA and all the trouble that comes their way. Oh, okay. I was making it way too deep, huh? You like, Pam, stop being deep with everything. You already got Thurgood Marshall in the back. We get your point. All right, y'all. Thank you guys for hanging out with your girl. We got over 1,000 in this live on a Sunday. So shout out to y'all. Shout out to everybody. Crystal W, thank you, new member. Gwen, thank you, new member. Again, M. Bahati Kumba, thank you so much for the $5 super chat. Steph Two Fly, thank you for becoming a member. Michelle, thank you for the $10 cash app. Michelle A, thank you again for being so super kind with the $50. And Lily Sweet, you're so kind with the $19.99. I hope you guys enjoyed the rest of your Sunday. Thank you again for continuously rocking with me, supporting me, and helping this channel grow. We are growing rapidly, and I am so proud. I'm so proud. I will be on tomorrow. I'm not sure if I'm just going to share the link, but Ernesto Williams will be having a bond reduction hearing. I plan on streaming it on my platform. That judge actually streams it on YouTube, but I just went and got some permission to share her live. So hopefully she doesn't switch it up and doesn't share it. If not, then perhaps I'll get the link. But nevertheless, my plan is to be over here. I want you guys to be over here at 5 o'clock so we can see if Ernest Williams, the future ex-husband, estranged husband, not husband, I don't know, see if he will get a lowered bond for his child depiction charge. And that's what we will be doing over here tomorrow at 5 o'clock. I hope to see each and every one of you guys over here so that we can discuss it together after the fact, because I'm sure you guys are interested to see, will this attorney tighten it up? I think she's going to tighten it up because I talked about her. She's going to tighten it up, and she's going to know a little bit about her own case. And we'll see if Judge Manning actually lowers his bond or keeps it at as it currently is, which is $800,000 on an unindicted child depiction charge. It's $200,000 per count, and he's trying to get it lower. Again, it kind of doesn't make a difference at this point, because when he was in Judge Kimberly Esmond Adams' courtroom, she denied bond on some very serious charges. So he won't even get out if it gets lowered, because he doesn't have a bond on that charge. But at least I guess it's one step closer, just in case they do decide to give him a bond on the other case if he does another motion and actually put some facts with it this time, then perhaps he'll get there. But that is our agenda for tomorrow. So I want you guys to make sure you come over here and watch it with me. But until then, Lord willing, I will see you tomorrow. I'll talk to you guys later. Hit that like on the way out and hit subscribe if you haven't done so already. Talk to you later.